Hotep, I am the Amen Osiris, the one and only undisputed God of law. We are Deception Stoppers, America's only 4D education service. I am the 4D Destroyers. I'm not a lawyer. This is not a law firm. We don't advocate you don't support your human offspring. We simply advocate that you made them in private, take care of them in private. All right. And what I'm going to do is just do a little refresher. And again, you can sue any 4D contractor on these bases. Now, listen to me very carefully. I'm just going to do a couple of case laws because I got about 1,000 of them, but we don't have that much time. Once the United States waives its immunity and does business with its citizens, it does so as a party never cloaked with immunity. Franconia Associates versus United States. When the United States enters into contract relations, its rights and duties therein are governed generally by the law applicable to contracts between private individuals. Again, Franconia Associates versus United States. It was conceded in the argument that when the United States becomes a party to commercial paper, they incur all the responsibilities of what a private person under the circumstances. Title 4D is contract law. 45 CFR 302.34, 31 USC 6305. Once the United States goes into those contracts, they automatically lose immunity. When the state or the United States deals in commercial private paper, it does so without immunity. All right, here's a couple more. The United States, a drawee of commercial paper, stands in no different light than any other drawee, as stated in Go United States versus National Bank. The United States does business on business terms. It is not exempt from the general rules governing the right and duties of drawees by the largeness of its dealings and its having to employ agents to do what if done by a principal in person would leave no room for doubt. Clearfield Trust. Okay, so once that contract is signed and they become a contractor, they automatically lose immunity. Okay, once they go into hustling and bustling commercial paper, they lose immunity. And here are the case law. This is just a few of them. All right, so the Yearsley Doctrine does not apply because the 11th Circuit Court can't overrule the United States Supreme Court. Once the United States Supreme Court makes a ruling, it sticks until it is overturned. None of these cases have been overturned. Okay? You need help? Bang my email at 4D_destroyer@yahoo.com. Right? We have the case laws, we have the facts, and we have the proof. There is no immunity for 4D contractors. I don't care what the 11th Circuit said. The Supreme Court, the United States Supreme Court said, you don't get it because you're under a contract. And it is right here. Okay? So the United States is doing business with its citizens. It does so as a party never cloaked with immunity. When the United States enters into contract relations, its rights, duties, and therein are governed generally by the contract law. Okay? So, once again, you have Cain, you have learned. Okay? We are deception stoppers, the 4D destroyers, and those who want to be, they're also destroyed. All right. So do your research. Research these case laws. It's just a couple of them. Like I said, I have thousands of them from case texts. Right? And you go from there. It doesn't matter whether you sue or not. What matters is that you do something about your current situation. But you can sue them if you want, because now they're under a contract. They were never cloaked with immunity. Hotep.